path for us to justice has been adversarial, it has been expensive, it has been time-consuming, and as such, it has been largely inaccessible.
If you go into court and all you know is you might lose your kids, or you might have some property rights, or you might have some pension rights, and you don't know how to protect those rights, and you don't have access to somebody who can tell you how to do that, then effectively the courts are failing you.
Some of our clients come with a culture that distrusts and is suspicious of the legal system. Some in the Chinese community will not take family issues outside the family, for to do so would be a loss of face.
The Right Honourable Beverley McLachlin, PC, Chief Justice of Canada, arrives at Vancouver's Morris J. Wask Centre for Dialogue. She will be the keynote speaker at the Law Society of BC's first Free Public Forum of 2009, exploring the barriers to accessing the justice system and creating solutions to break down obstacles. The first stop is a meeting with the Law Society benchers.
All the privileges we enjoy as lawyers, the responsibilities we have as judges, these are conferred upon us for one purpose, and that is to serve the public. This province has, and its Law Society and its Judiciary and its Attorney General have been at the forefront of steps to improve the justice system. Improve in the sense of making it accessible, not just to a small number of people or corporations, but to everyone.
More than 250 participants gathered in the Wask Centre for Dialogue for the forum, moderated by CBC radio host Mark Forsyth.
We're going to hear about the barriers to accessing justice, a problem for more and more lower and middle income earners in this country. And in these uncertain times, it's becoming even more difficult, or it could be.
After teaching law, Chief Justice McLachlin became first a judge of the County Court of Vancouver, then a judge of the Supreme Court of British Columbia, and I hope I have these in the right order, then a justice of the Court of Appeal for British Columbia, then Chief Justice of the Supreme Court of British Columbia, and then a Justice of the Supreme Court of Canada, and since January of 2000, Chief Justice of Canada. This means that Chief Justice McLachlin is the highest ranking judge in the country, and we're delighted to have her here today. The Right Honourable Beverley McLachlin, Chief Justice of Canada.
I adhere to the view that justice is a basic good to which every member of society is entitled. Everyone should have access. I believe this to be supported by history, by the need for stability in our society, and by what it means to be a human being possessed of dignity. Without legal help, people may face months, if not years, of personal difficulty as they attempt to navigate the sometimes complex demands of the law and procedure. What these people are telling me is that they've been denied access to the justice system and hence to justice. But in many cases, complex court procedures in fact can work on fairness because they are too complex for cases that are concerned with simple factual disputes, for example, or do not involve large amounts of money. If procedures are too complex, they cause delay and drive up costs. There are no easy answers in this area. Government, the courts, and the legal profession must each play their part and must work together if we're to bridge the disconnect between our ideal of access to justice and the reality of access too often denied. We're seeing the beginnings of such efforts. Departments of Justice and Attorney Generals across the country are reviewing and revising court procedures in concert with the bar, both in the criminal and civil areas. Courts and judges are seeking to improve access to justice by streamlining and opening their procedures and promoting efficient and early dispute resolution. The bar is playing its role, for example, through pro bono service initiatives, that is, where lawyers provide services at little or no charge, and by exploring possibilities such as unbundling of legal services, where a lawyer helps a litigant with specific aspects of his or her case.
In the mid-90s in California, our family courts had between 70 and 80%, 70 to 80% of all litigants in family courts had no lawyer. This is unconscionable. And the innovation that we came up with is called unbundling. Sometimes it's called limited retainers. Sometimes it's called limited scope representation. And what it says is that we train lawyers how to take a legal matter, break it into pieces, so they can focus their attention on the area where it makes the most difference. The legal issue which is most complex, or the issue which is most important to the litigant, so they can get quality legal help to pursue their case or defend their rights, and then they can be coached on handling the simpler areas themselves.
Today, over 100 programs are offered by approximately 400 professional staff and more than 2,000 active volunteers. One of these programs is the Pro Bono Legal Clinic. Another is our education program to teach new Canadians about the Canadian justice system.
The final portion of the evening was dedicated to answering questions from the floor.
Given that data informs policy and practice, how can we adequately measure if we are making improvements without collecting good data on Aboriginal people, and particularly in the policing context here in British Columbia? And we only have to remind ourselves of what's been happening in the news regarding inquiries and the tragic story of the women who've gone missing in our own city.
More data is necessary, and that comprehensive data is necessary with respect to violence against Aboriginal women. I have met with a number of different groups of Aboriginal women who have expressed considerable concern, particularly for the missing women.
Who or whom do you see to be the most at risk in our population with regards to these recent cuts to legal aid?
There's an awful lot of people at risk that if their problems aren't resolved, they'll cascade into more serious problems, they'll result in health and social service costs.
It was left up to BC Attorney General Wally Opal to summarize.
We need to offer solutions to people who come into our system. Otherwise, the public confidence level, which is low now, will deteriorate even further. Those of us who are in the system need to recognize and listen to the Canadian public when they're telling us that we need to reform our system.